Well, good afternoon, and thank you, Dean Matheson, for this introduction. I do appreciate it very much, and I'm honored to be here today, and thank you for having me. It is clear that our nation, our state legislators, and Supreme Courts throughout the country are confronting this controversial subject of aid in dying. So I want to congratulate the UNM School of Law, Deans Matheson and Dean Pareja, and all of those involved in bringing together such a large group of distinguished experts to our campus to lead this important dialogue. To the New Mexico Law Review and to the capable and dedicated law students who led and participated in this effort, I want to say thank you for all that you've done to enable UNM to perform this crucial role in providing an open and inclusive environment for important dialogues and for rigorous academic discourse, especially on topics that affect us all both nationally and locally. I understand that the New Mexico Supreme Court was one of the latest to address this issue of aid in dying, and that in 2015, the New Mexico Court of Appeals, which we're very fortunate to host on this campus, overturned a district court's ruling on a case related to this complex subject. For these reasons and more, I am pleased to have the opportunity to welcome to our university campus and to New Mexico's best and only law school, both the national scholars and the local experts who have been actively exploring this issue and leading many important dialogues on their own. With that said, it's now my honor to welcome to our campus and to recognize the accomplishments of today's keynote speaker, Dean Erwin Chemerinsky, the Dean of the University of California, Berkeley School of Law. After serving as the founding Dean of University of California Irvine School of Law from 2008 to 2017, the Dean was recently appointed to be the Dean at the University of California Berkeley School of Law, and we congratulate him on this newest significant accomplishment in this already impressive academic career. Dean Chemerinsky is a prolific scholar, as many of us know, and is the author of 10 books and more than 200 law review articles. I'm actually in the middle of reading his latest, the Free Speech on Campus book. And I did find out that he shares something else with one of our co-deans, one of our deans. He was, in 2011, selected as one of the 23 law profs to take before you die. The other one was Dean Sergio Pareja. One of the others. There were many others. Dean Chemerinsky is a leading scholar on state constitutions. In January 2017, National Jurist magazine again named Dean Chemerinsky the most influential person in legal education in the United States. Today, Dean Chemerinsky joins us to present his thoughts on the history of state constitutions in providing civil rights in this and other arenas, and on our state constitutions as the future for civil rights. Most importantly, he's missing the USC-Cal game to be here with us today. So at 2:30, the game was 2:30 here, 1:30 in California, the game will start. So please help me in welcoming Dean Erwin Chemerinsky to the stage.
Thank you so much. President Abdallah, thank you so much for that very kind introduction. Thank you for the warm welcome. It's truly an honor and a pleasure to be here. Just to be clear, a number of people have mentioned my having to catch a flight. I know it's rude to leave before the end of the conference. It is not for purpose of the USC-Cal game. I promised to be in Los Angeles tonight for my granddaughter's first birthday party. So. In March of 1993, my father was in a hospital in Hammond, Indiana, dying from lung cancer. The cancer had spread. The tumor had grown so much that it was cutting off circulation to his arm. It had become grotesquely swollen. There was concern that gangrene would set in. A doctor wanted to amputate his arm. My dad, who was fully lucid, said he was going to soon die, and it didn't matter whether it was in the lung cancer or the gangrene. He didn't want his arm amputated. On Monday, March 15th, a doctor came into his room in the afternoon. I and my siblings were in the hospital room. And my dad said to the doctor, I know I'm never going to get out of this hospital bed. Can you simply increase the amount of morphine you give me so that I don't wake up? The doctor very rudely said, "No, we can't do that." And the doctor began to turn away. My dad, to the end, was quite persistent, and he said that he was either drugged in unconsciousness or in excruciating pain. Could the doctor please just add enough morphine to end his life? The doctor didn't say anything. He simply turned his back on my father and walked out of the room. My dad died 4 days later on March 19th. Never did get out of that hospital bed. And I will never understand interest the state of Indiana had in prolonging my dad's life for those 4 days. The law is no different today in Indiana than it was in March of 1993. Even though almost 25 years have gone by since my dad passed away, still in Indiana, there is no right to physician aid in death. There's no right to physician-assisted death. And that remains true in the vast majority of states throughout the country. Why is it that there's been so little progress in this area? What does it tell us more generally about constitutional rights? And what should we do about it as we look to the foreseeable future? Those are the questions that I want to address this afternoon. I'll divide my remarks into 4 points. First, there is not a right to physician assistance in death, and there's not going to be a federal constitutional right for the foreseeable future. In fact, we're likely to see very little expansion when it comes to individual rights under the United States Constitution for the foreseeable future. I think you have to put this in some historical context. The Warren Court, which existed from 1954 to 1969, brought about a tremendous expansion in civil rights and civil liberties. It was the Warren Court that was largely responsible for applying the Bill of Rights to state and local governments. The Warren Court recognized countless new individual liberties. It was the Warren Court that for the first time said there was a right to privacy found under the Constitution. It includes a right to purchase and use contraceptives. It was the Warren Court that said there's a right to travel under the Constitution. It was the Warren Court that protected aspects of autonomy, such as the right to custody of one's children, the right to keep the family together. But all of this changes at the end of the Warren Court, 1969. Between 1969 and 1971, Richard Nixon got to appoint 4 justices to the Supreme Court. From 1971, when Richard Nixon's 3rd and 4th justice were confirmed for the court, until February 13th, 2016, when Justice Antonin Scalia died, there were always at least 5 and sometimes as many as 8 justices appointed by Republican presidents. Since 1971, only on rare occasions has the Supreme Court found new individual liberties or expanded the scope of individual rights. I think a key case in this regard was early in the Burger Court era, in 1973, in San Antonio Board of Education versus Rodriguez. This was a challenge to the Texas system of funding public schools largely through local property taxes. This resulted in tremendous disparities. Wealthy suburbs could tax at a low rate of assessment and generate a great deal to spend on education. Poor areas would tax at a high rate and had little to spend on education. But the Supreme Court, 5-4, found no violation of the Constitution. All 4 Nixon appointees were in the majority, joined by Eisenhower appointee Potter Stewart. Justice Lewis Powell wrote for the court and said, "There is no right to education under the United States Constitution." If there's no right to education, hard to imagine what other rights the court will find to be protected. I can count on less than the fingers of one hand the additional constitutional rights that have been recognized by the Supreme Court since 1971. Of course, there's Roe versus Wade and the right to abortion, 1973. There are Supreme Court cases expanding rights for gays and lesbians, Lawrence versus Texas, which was discussed this morning, in 2003, that said a state cannot criminally punish private, consensual same-sex sexual activity. Oberfeld versus Hodges in 2015 that said that state laws that prohibit same-sex marriage are unconstitutional. But I challenge anyone in this room to think of many instances beyond these where the Supreme Court has recognized new constitutional rights. If you focus on the subject for today's wonderful conference, you see again the Supreme Court refusing to recognize what I see as the most fundamental aspect of autonomy, a right to death with dignity. There was brief mention this morning of Cruzan versus Director of Health Services from 1990. But what wasn't mentioned was that Chief Justice Rehnquist's majority opinion said that the court was assuming without deciding that competent adults have a right to refuse life-saving medical treatment, including food and water. To be sure, Justice O'Connor had a concurring opinion. The 4 dissenting justices said they believe such a right exists. But to this moment, never has the United States Supreme Court said there is a fundamental right of competent adults to refuse medical treatment. And of course, there was much discussion this morning of the Supreme Court's decisions from 1997 in Washington versus Glucksberg and Vacco versus Quill, where the Supreme Court reversed 2 federal courts of appeals, the Ninth Circuit and Second Circuit, and unanimously held that there is no right to physician-assisted death. This, then, is the context for today's program, is the context for talking about right to physician aid in death. It's the context for talking about constitutional rights more generally. It's worth pausing for a moment and asking why. My answer to that question is it's been the hostility of conservative justice on the court to individual liberties. Now, the tempting response to that might be, it's really about the court recognizing the proper role of the judiciary relative to the legislature. I think if you look at the behavior of these conservative justices on the Supreme Court, you see that as an explanation that is, frankly, nonsense. These same conservative justices had absolutely no problem in striking down the D.C. ordinance prohibiting private possession ownership of handguns. There's no deference there to the legislature, a 35-year-old ordinance. These same justices have no problem in striking down affirmative action programs adopted by popularly elected legislators, boards of regents that are appointed by them. These same 5 conservative justices have no problem in striking down campaign finance laws adopted by Congress, such as in Citizens United versus Federal Election Commission. So if it's really about deference to the legislature, where was it in the area of gun control or affirmative action or campaign finance? I think the only way to understand is that these justices are hostile to the individual liberties that are involved, and that's what's reflected in the cases that I've mentioned. I think this isn't going to change for the foreseeable future. I was hopeful before November 8th of 2016 that there would be, for the first time in my adult life, first time since I became a lawyer, 5 justices appointed by Democratic presidents. But we saw something unprecedented in American history. Prior to 2016, 24 times in American history, there was a vacancy on the Supreme Court in the last year of a president's term. In 21 of 24, the Senate affirmed the nominee. In 3 instances, the Senate denied confirmation. Never before in history have the Senate said, no hearings, no vote on a presidential nomination for the Supreme Court. We're not going to have Merrick Garland replacing Antonin Scalia. Instead, we have Neil Gorsuch. And let there be no doubt that Neil Gorsuch is going to be a very conservative justice on the court. In fact, I think he might be more conservative than the justice he replaced, Antonin Scalia. We tend to forget that there were areas where Justice Scalia joined with the more liberal justices. Justice Scalia was often a pro-free speech justice. For example, if you think of the 2 Supreme Court cases that held that flag burning is constitutionally protected speech, they were 5-4 with Justice Scalia in the majority. In recent years, Justice Scalia wrote a number of dissents in Fourth Amendment cases, joined by Justices Ginsburg, Sotomayor, and Kagan, wanting more protection of privacy rights. It was Justice Scalia who led the court in expanding the rights of criminal defendants under the Confrontation Clause of the Sixth Amendment in Crawford versus Washington and the rulings that followed it. I can't identify any areas where Neil Gorsuch is likely to join with the more liberal justices. Neil Gorsuch was sworn in on April 8th of this year. If you look between then and June 26th, the last day of the term, Neil Gorsuch voted together with Clarence Thomas 100% of the time. In fact, Neil Gorsuch and Clarence Thomas joined each other's opinions 100% of the time. To put this in some context, we usually thought of Justices Scalia and Thomas as ideologically similar. In their last full year on the court, they agreed only 84% of the time. Neil Gorsuch is 49 years old. If he remains on the Supreme Court until he's 90, the age which just John Paul Stevens retired, he will be on the bench for the next 41 years. As I said to my students, he'll then be a justice to the year 2058. It seems so likely that there will be another vacancy on the Supreme Court between now and January 20th of the year 2021. Did you know that since 1960, 78 years old is the average age at which a Supreme Court justice has left the bench? As we're together today, there's 3 justices who are 78 or older. Ruth Bader Ginsburg turned 84 on March 15th. Anthony Kennedy turned 81 on July 23rd. Stephen Breyer turned 79 on August 15th. If any one of these 3 justices leaves the bench between now and the end of the Trump presidency, it'll create the most conservative court there's been since at least the mid-1930s. Now, believe that Justices Ginsburg and Breyer will stay on the court to the end of the Trump presidency if their health allows them to do so. Many remark that Justice Ginsburg appears so frail. I first met her in 1986 when she was a judge on the D.C. Circuit. She looked really frail then, too. And I've got to believe that Justice Ginsburg and Breyer have told their clerks, if anything happens to them, just keep them on the bench and keep voting. But there's rumors that Justice Kennedy could step down as soon as next summer. And of course, we're also talking about individuals who are 84, 81, and 79 years old. Have to believe that one or more will be replaced by President Trump. And that then means that there will be a conservative court for the rest of my career, the rest of my lifetime, and for those of your law students, most of your careers as well. So it seems to me it's fanciful to think that there's going to be a Supreme Court to expand constitutional rights generally or find a right to physician aid in dying more specifically. That brings me to my second point. We need to turn to state constitutions for the expansion of civil liberties and civil rights. This isn't a new idea. William Brennan published an article in the January 1977 edition of the Harvard Law Review urging the use of state constitutions to advance liberty and equality. Justice Brennan had seen the shift in the court, the beginning of the Burger Court era, the end of the Warren Court, and he realized that it was unlikely, given the justices that Richard Nixon had put on the court, that there'd be a bench to expand rights for the foreseeable future. So Brennan, who had been at the very center of the Warren era, said, let's look to state constitutions as the new source for expansion of rights. There's much to be said for this approach. States always can provide more rights than the United States Constitution. A famous example of this in the First Amendment era was the Supreme Court case Pruneyard versus Robbins. The United States Supreme Court had ruled that there's no First Amendment right to use privately owned shopping centers for speech purposes. But the California Supreme Court, interpreting the California Constitution, found that there was a state constitutional right to use privately owned shopping centers for speech purposes. And the Supreme Court, an opinion by none other than then Justice William Rehnquist, said that states always, under their state constitutions, can provide more protection of liberty. And there are many areas across the country where state Supreme Courts have done this. I think of the states that have provided more protections with regard to searches and seizure than the United States Supreme Court has found the Fourth Amendment. States that have found more protection of individual autonomy than the United States Supreme Court has found under the liberty of the due process clauses. There's also the benefits sometimes in litigating in state court of much more specific enumeration of rights in state constitutions than exists under the United States Constitution. It was mentioned this morning that the state of Montana has a dignity clause in its constitution, key to the ruling in Baxter versus State. A number of states, like California, like Alaska, enumerate a right to privacy in their state constitutions. Many states create a right to education and enumerate it in their state constitutions. Many states have provisions that create a right of redress, a right of access to the courts. All of these provisions provide a basis for litigation in state courts under state constitutions when same litigation might not succeed in federal courts under the United States Constitution. Also, there's the reality states can be laboratories for experimentation. States can be models for one another. This idea that state governments can be laboratories for experimentation is nothing new. Justice Louis Brandeis articulated early in the 20th century. It's a concept that was known even before he uttered these words. And so a state can find a right in its constitution that can influence other states and ultimately might even be found in the United States Constitution. That's, of course, exactly what happened with regard to marriage equality. In 1993, the Massachusetts Supreme Judicial Court became the first judicial body in this country to recognize a right to same-sex marriage, declaring unconstitutional a Massachusetts law that prohibited same-sex couples from marrying. The Massachusetts legislature then asked the court, could we just provide for civil unions for same-sex couples? And the justices responded, no. Separate but equal is no more allowed in this area than any other. A number of other states followed the lead of Massachusetts. Iowa and California, for example. Soon this led to litigation in federal court, and it culminated in Obergefell versus Hodges on June 26, 2015, where the Supreme Court held that there is a constitutional right for same-sex couples to marry. I remember after the decision of the Massachusetts Supreme Judicial Court in 2003, saying that I believe that in my lifetime there'd be a right of gay and lesbian couples to marry. But when I said that, I could never have imagined that it would occur within just 12 years. And it wouldn't have happened without state courts and state constitutions. I think once Massachusetts and other states recognized a right to same-sex marriage, the country could see there were no undesirable consequences. It was affirming of the right to marry and of the institution of marriage. And that then very much influenced what the Supreme Court did. And yet I've got to tell you, I have only 2 cheers, not 3, for state constitutions. I think in some ways they are a second best. Some of it is the sheer inefficiency of protecting rights at the state level. There are 50 states plus the District of Columbia, so just there's 51 jurisdictions to litigate. It is much easier to get the United States Supreme Court to recognize a right for the whole country than have to litigate state by state under each individual state constitution. Also, the reality is, when it's done at the state level, there will be successes and there will be failures. We tend to forget that there were some state Supreme Courts, highest courts, that refused to recognize a right to marriage equality. The New York Court of Appeals, 4-2, said there was no right to same-sex marriage in New York, that the prohibition of marriage equality didn't defend the New York Constitution. And so when we settle for litigating in state courts, because we can't win at the federal level, it means in some parts of the country, those rights will be protected, but not in others. And then that exacerbates inequalities on the basis of wealth. People who have money can travel to the states where rights are protected. People who don't have the resources can't. I believe that if President Trump can replace Justice Ginsburg or Justice Kennedy or Justice Breyer, there will be 5 votes to overrule Roe versus Wade. Then about half the states will prohibit all or almost all abortions. Women with resources will be able to travel to places like California and New York, where abortion is safe, legal. Did you know that before New York was the first state in this country to legalize abortion, over 40% of the abortions in England were performed on American women? It wasn't poor women who were traveling to England for abortions. Leaving things to state-by-state determination means those who have money will get the rights. Those without won't. And to me, that's very troubling. But that's the context of litigating in the states. And so it then brings me to the third point of remarks, and that's at least when it comes to right to physician aid in dying, we've not been successful in terms of state courts and state constitutions. I mentioned to you that not much is different in the United States today compared to when my dad died in March of 1993. There's been an occasional success, Baxter versus State in Montana that was discussed this morning. But more often, there have been failures to litigate right to physician aid in death under state constitutions. I think that we're here today because of the decision of the New Mexico Supreme Court in Morris versus Brandenburg. As was mentioned just this month, the New York Court of Appeals in Meyer versus Schneiderman rejected a right to physician assistance in death under the New York Constitution. Why is it then, if there are these state constitutions and provisions that can be looked at within them, has there not been more success? And what might this tell us more generally about litigating constitutional rights under state constitutions? In part, I think the lack of success reflects a general lack of tradition of strong state constitutionalism. I don't want to overstate this. I could point to many examples where state courts under state constitutions have protected more rights than under the United States Constitution. But I would say that overall, we have in the United States a very weak tradition of using state constitutions to provide more protection for rights than the United States Constitution. I think what we've seen with regard to the rejection of right to physician assistance in death under state constitutions parallels many other failures to try to expand rights and liberties in state constitutional law. Now, in part, this might be that in the majority of states, state judges face some form of electoral review. 41 states subject state court judges to some review at the polls. In some states, it's just judges running like other politicians in partisan elections. In some states, it's retention elections. In California, it's a mixture of judges run in nonpartisan contested elections for the trial court and retention elections at the appellate and Supreme Court level. I worry that electoral review makes it less likely that judges in many states will be courageous, finding rights and liberties, especially when they're controversial. Otto Kaus served with great distinction for many years on the California Supreme Court. And he said, facing judicial retention elections is for a judge like having an alligator in your bathroom. He said, you never forget that it's there. Studies have been done that compare the rate of affirmance and reversal in death penalty cases among state Supreme Courts where the justices face some form of electoral review compared to those who don't. And there is a dramatic difference where judges who are going to have to go before the voters are far less likely to overturn death sentences. To me, that shows electoral review does have some effect with regard to judicial behavior. Point here to an example that I alluded to a moment ago very briefly. The Iowa Supreme Court, after the Massachusetts Supreme Judicial Court, unanimously found a right to marriage equality for gays and lesbians under the Iowa state constitution. At the next election, 3 of the justices from that 5-member court were up for review. All 3 were denied re-election. I have to believe that judges across the country took note of this, and it does have an inhibiting effect in terms of the use of state constitutions. I also worry when it comes to the use of state constitutions that the overhang of federal constitutional law has great sway. Let me take the area we're speaking of today, a right to physician assistance in death. Both the New Mexico Supreme Court and the New York Court of Appeals cited to the United States Supreme Court's decision in Washington versus Glucksberg. There, the United States Supreme Court said that the challenge to the laws prohibiting physician-assisted death only had to meet rational basis review. Those decisions should have been absolutely irrelevant to the New Mexico Supreme Court or the New York Court of Appeals. That's how the United States Supreme Court interpreted the United States Constitution. As I said, as you know, states always can provide more protection of rights under the state constitutions. Even though there's no fundamental right to physician-assisted death under the liberty of the due process clause or the equal protection clause of the 14th Amendment, that doesn't mean that a state, under its state constitution, can't find such a fundamental right. The state, of course, is free to use heightened scrutiny, even if the United States Supreme Court rejected it. But you only have to read the opinions in Morris and Myers and get a sense that the Supreme Court's determination had a real influence in the way those state highest courts looked at the issues. And so, at least as we speak today, there's been very limited success under state constitutions with regard to the realm of what we're discussing, autonomy with regard to medical decisions, especially in regard to physician assistance in death. So that brings me to my 4th and final part of my remarks. What do we do about it? What now? I think I've sketched for you the reality as we're together, but where do we go from here? Well, as we discussed this morning, one possibility is to go to state legislatures or to use the initiative process to adopt state laws. This has been successful in a few places, and as was mentioned this morning and a couple of others, initiatives failed only by the slimmest of margins. I applaud these efforts. I've worked in favor of these efforts. And yet also, I recognize the limitation of these efforts. To start with, I don't like the idea that what I regard and what I think should be regarded as a fundamental right is left to the political process. Long ago, the Supreme Court recognized that we put rights in the Constitution precisely to take them out of the usual political process. I believe that the Constitution and its guarantee of liberty protects basic autonomy for each of us. And that autonomy does include the ability to make the profoundly crucial decision of whether to have death with dignity, whether to live or die, especially in the face of a terminal illness. Also, successes in legislatures have been relatively rare. You saw the statistics this morning. And it's worth all of us in this room thinking about, why has it been so hard to get these bills through legislatures? Why haven't more initiatives the sort that passed in a few states been adopted in others? I speculate, but I think some of it is the power of single-issue lobbyists that intensity of preference has disproportionate weight in our political system, and there is intense opposition to protecting a right to death with dignity. Often the opposition is religiously based. I think it's also been very difficult to rally widespread support for this legislation or these initiatives. I'm not a psychologist, so I really am speculating, but my guess here is that it's about how none of us really want to face our own mortality. We don't want to contemplate what it will be. It's us that has to face terminal illness, excruciating pain. I'm a lawyer and a law professor. I've taught the Cruzan case every year since it came down in 1990. And until just a year ago, I didn't have a living will. Every time I taught the case, I said to my students, if I'm ever in the situation of Nancy Cruzan, I don't want to be kept alive in a persistent vegetative state. And then I didn't do anything about it. And if I didn't, then doesn't it help to explain why most people don't want to confront this issue? And then doesn't that help explain why it's been so hard to get legislation passed? So we have to work hard in order to get legislation passed, because we may not succeed in states under state constitutions, and we're not going to succeed under the United States Constitution in the Supreme Court. I think we need, more generally, to put much more emphasis and attention on state constitutions than ever before. And here I think law schools and law professors deserve a great deal of the blame. At least until this year, I have never taught at a law school that offered a course on state constitutional law. I know that many law schools do, but the University of California, Irvine, Duke, USC, DePaul, the places where I've taught before now, never had such a course. My guess is these law schools are more typical than unrepresentative, and I now believe that we're wrong to not do so. That if we're going to have lawyers litigating under state constitutions and judges adjudicating them, we need to be teaching law students about state constitutional law. If you look at law professors, relatively few of them are writing about state constitutional law. If you look at the most prominent of law professors in the country, you don't see them writing articles about that. The field of constitutional law, they'll write about the United States Supreme Court, but rarely turn their attention to what we're talking about today in litigating our state constitutions. Law schools need to change this if state constitutions are going to be the source of rights for years to come. I think as we go forward on the issue we're discussing today, those of us who care about it really need to engage in a public education campaign far better and more effective than ever before. The opponents of physician assistance in death, so easy to point to the possibility of abuses. But we've now got data, including that presented this morning from the state of Oregon. We see how rare abuses are in this country, even when there's physician-assisted death. We see that often, as was mentioned this morning, people who get prescriptions that would allow assistance death don't take them, but are comforted by their existence. You saw the studies this morning of how family members, instead of being traumatized, are helped by allowing physician assistance in death. We need to get all of this out. We need to get this message out to state legislatures. We need to get this message out to the general public that's considering these initiatives. And we just haven't done a very good job of it so far. In April of this year, our 16-year-old dog, Nadia, needed to be put down. By that point, she was deaf and blind and regularly walking into walls. She was incontinent. It was difficult for her to stand as her back hips were giving out. And we realized that the most compassionate thing would have put out of her suffering. We called a vet that came to our house, and in the piece of our backyard, with us petting her, gave her a shot to end her life. And I realized when that happened that we treat our pets so much more humanely than we treat our loved ones. I was thinking about my father, when all of this happened. I realize that this afternoon I have painted a fairly bleak picture about the topic that we're discussing today, or more generally, the future of our constitutional rights. And I realized then that we have only two choices when confronted with this reality. We can give up, or we can fight harder. And I think that the reality that I have described this afternoon means that if we care, we're going to have to fight harder, better, more effectively than ever before. Thank you.